Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the jurisprudential aspect of law and morality as stated by our Honorable Chief Justice in India, Dr. Y.V. Chandrachud. So, while giving a memorial meeting in memory of late Desai, Ashok Desai, who worked as the Attorney General also, Justice Chandrachud expressed the positive legal positivism or positive morality or the relation between law and morality, which we have discussed in the beginning of our jurisprudence class. That's why I told you also that the concept of dharma, the concept morality, definitely they found major place in the basis of our law, right? Definitely. So the origin of law can be traced to morality. In the beginning of the Roman law, please remember the strict adherence to the contracts and also acting in good faith were left to individuals. అందుకనే మనం ఆ కాలంలో మంచి ధర్మం 4 పాదాలు నడిచింది కాబట్టి దే యూస్ టు బి మోరల్, బట్ ఆఫ్ కోర్స్ స్లోలీ they have changed. Therefore, to regulate the external conduct of the people, something necessary, that is law. So law regulates the external relations and morality governs the inner concern, inner motivation. This is what he has stated. So this is one part. But at the same time, while delivering the same speech, he made some other comments also. Because you know that there is an ongoing conundrum or confrontation between the judiciary and legislature, particularly during the recent past. So I will explain that in the next video. But here to start this also, I have to go the political reason. Very recently, in the parliament, Honorable Law Minister Sri Kiran Rijiju, he stated that Supreme Court need not go into simple issues like bail petitions and other things. They have to look after the constitutional matters. Already heavy pendency is there. That means the inner indication is that Supreme Court is taking up the trivial bail matters also. For that, Honorable Justice, Chief Justice of India retorted stating that there is no big case, there is no small case. Every case is equal before us. No case is small or no case is big. Trust us, we are the guardians of the law, or we are the guardians of the civil liberties. Memu పౌర హక్కుల సంరక్షకులము అని చెప్పి అన్నారు. So this happened just yesterday, 17/12/2022. Trust us to be the guardians of liberties of the citizens. There is no case which is small or which is big enough for any court in the country. Please remember, in the nation, due process of law, rule of law and protection of the liability should be there. So this can be treated as a counter to the minister's comments that the Supreme Court can take up only the constitutional matters but not the trivial petitions like bail petitions, but simple cases. I has given example also. CJI has given another example. A person who is convicted under electricity offense, Indian Electricity Act, he was confined for about 18 years for the simple theft. You know the punishment for theft? How much? Only 3 years. So the magistrate forgot to mention, of course, no doubt he was involved in 18 theft cases. You may be knowing 3 cases will be clubbed as a charge under CRPC, but whatever it is, so he was convicted, but the consecutive sentences, they were not mentioned in the magistrate report. So magistrate, while delivering the judgment, he has literally forgotten to mention that all the sentences shall run concurrently. So since it was not mentioned consecutively, that means after one judgment, second judgment, అంటే సహజంగా ఒక కేసులో శిక్ష పెట్టిన తర్వాత 2 ఏళ్ళు అయిపోయింది, మళ్ళీ 2 ఏళ్ళు, మళ్ళీ 2 ఏళ్ళు, మళ్ళీ 2 ఏళ్ళు. బట్ కంకరెంట్లీ అంటే అన్నిటి కలిపి ఒకేసారి అవుతుంది. అందుకనే సెక్షన్ 31 సిఆర్పిసి కూడా ప్లీజ్ రెఫర్ టు. అందుకనే 31 సిఆర్పిసిలో క్లియర్గా రాస్తుంది. సో వాట్ ఎవర్ బి ది కన్విక్షన్ పీరియడ్ షుడ్ నాట్ ఎక్సీడ్ 14 years. దాంట్లో ఇంకా చాలా ఉంది, మీకు సింపుల్గా అర్థం కాదు. 14 years. అందుకనే పాతకాలంలో యావజ్జీవ శిక్ష అంటే 14 ఏళ్ళు అన్నాడు. ఇప్పుడు అలా కాదనుకోండి, ఇప్పుడు యావజ్జీవ శిక్ష అనేది క్లియర్గా రాస్తున్నారు. టిల్ ది ఎండ్ ఆఫ్ హిస్ లైఫ్ అని రాస్తే చచ్చిపోయేంత వరకు యావజ్జీవ శిక్ష. బట్ హియర్ that is not by the CJI. It plays on a high note. Because if the Supreme Court has not come to the rescue of this man, he would have been in jail for the continuous 18 years, is it not? So, okay. After all, it's a small case, a theft case, where the punishment is only 3 years. Who is bothered? Even Jilla Judge Garu Batishkor. But still the matter has come to the Supreme Court and they have looked into the case. Inko case kuda undi. Very recently, an LLM student filed a case against the principal of a college that he is actually keeping a book of Hindu phobia in the library in Mindore. So the High Court stated that since he was the principal, he has got the responsibility, even though he said he was not the principal of the particular type. The High Court did not hear. In FIR it was there, that's all. But when the matter came to the Supreme Court, that too before the Honorable Chief Justice of India, yes, they have stayed the orders of the arrest. So definitely they have to do justice. There is no small case or there is no big case. So this is also commented by the Honorable CJI. So please remember, so the court is a court, whether it is a bail petition, whether it is an appeal or whether it is a constitutional matter, they will delve deep into the matter. So please remember, so as far as law and morality are concerned, so please remember, morals may vary or may change from person to person. So normally, you may be knowing about the honor killing cases because they are against to the morality, but people think that it is moral because their family woman marrying another person. So in UP it happened. He has cited the case of UP in, I think it happened in 1991, I think. So, two people loved each other and this boy, friend of the woman, he made them elope away from that place. He along with his friend. సో ఇద్దరు జంట వెళ్ళిపోయారు. అసలు ఎవరైతే తప్పించారో వాళ్ళిద్దరిని ఈ క్యాస్ట్ వాడు చంపేసి శవాల్ని వేలాడదీశారు. దట్ మీన్స్ సో దట్ ఇట్ గివ్స్ ఏ ఎగ్జాంపుల్ టు ది అదర్స్. ఇలా ఉంటాయి కాబట్టి దిస్ ఈజ్ నాట్ మోరల్. దే మే థింక్ దట్ ఇట్ ఈస్ నాట్ మోరల్. సో సచ్ థింగ్స్ షుడ్ బి కర్బ్డ్. సో పీపుల్ యాక్చువల్లీ దే వర్ ప్రౌడ్ ఆఫ్ సచ్ యాక్షన్స్, బట్ డెఫినెట్లీ it is a discrimination, should not be allowed. So this is the difference between law and morality. But so when we see the school of Jeremy Bentham or Austin's school, that is the positive school, positivism, legal positivism, definitely law and morality, they are coexistent. So from morality only the aspect of law has come. So this is what he has concluded. So the conclusion is good. Now I have told you the jurisprudential part of the speech given by Honorable Justice Chief Justice of India. At the same time, his comments on the smaller big cases and also the retort to the law minister's remarks. So please hear the video very carefully and definitely you will be enriched with the knowledge of legal knowledge particularly. Thank you very much.